we had a lot of questions about how the different leaves interact with each other and when reasonable accommodation applies or does not apply. So how do these different leaves interact with each other? We have the state and federally mandated leaves, and then we have reasonable accommodation. The first thing that should be considered is when you're looking to see whether or not one or more leave runs concurrently is what is the reason for the leave. So for example, pregnancy leave would run concurrently with FMLA, and then FMLA would run concurrently with CFRA for pregnancy after child is born. Pregnancy leave does not apply. There's baby bonding, and CFRA and FMLA would run concurrently for baby bonding. Then there is reasonable accommodation under pregnancy, and that would be if the employee has already used their PDL and they still are disabled and need additional leave, then it would be reasonable accommodation. Then under workers' compensation, the leaves that would run concurrently with a work-related injury would be, again, FMLA and CFRA. And then FMLA and CFRA would run perhaps concurrently if the employer chooses to run them concurrently for an employee's own serious illness or injury, which is not work-related. And then reasonable accommodation would apply under FEHA and ADA for additional leave that would be not protected. So leave under FMLA and CFRA would run concurrently, although some employers do choose not to run them concurrently, thereby providing additional protected leave to their employees. So for pregnancy, for a parent who just gave birth to a child, FMLA and CFRA would run concurrently for time taken to bond with the newborn or child placed for adoption or in foster care with the employee, for employee's own serious health condition, or to care for a covered family member or designated person under CFRA. Here, I want to note one thing, that CFRA provides broader coverage than FMLA, so leave taken for care for registered domestic partners, parents-in-law, siblings, grandparents, and all those, additional categories that are covered under CFRA, those would only be covered under CFRA. So anytime leave is taken for those reasons, they wouldn't run concurrently with FMLA because FMLA does not apply to those subcategories that CFRA provides for, but FMLA does not. Leave taken under CFRA only does not affect employees' time available under FMLA.
Then moving to what leaves run concurrently when an employee is on workers' compensation leave. And so obviously this is for a employee's health condition related to work. Keep in mind, workers' compensation is not a job protected leave of absence, it's just a benefit provided to the employee. However, if an employee goes on a workers' compensation leave, the employer should always analyze to see whether or not the employee is eligible and entitled to FMLA or CFRA. And if they are, then those leaves would be triggered. So again, if they are not eligible for CFRA or FMLA leave and they go on a workers' compensation, they're on workers' compensation injury leave, then you would then have to explore whether additional leave or some type of leave is applicable or warranted as a reasonable accommodation under the circumstances. Then PDL and FMLA running concurrently. So PDL, as you know, is for pregnancy-related disability, pregnancy, childbirth, or related medical condition. And once PDL ends, obviously, the employee can take baby bonding leave under CFRA. But when the employee is on PDL, FMLA can run concurrently with that. And then keep in mind, additionally, PDL and FMLA cover absences for prenatal care and serious conditions such as severe morning sickness. CFRA and FMLA runs concurrently, and that would apply once the child is born or there is a child placed in foster care or a child is adopted for up to 12 weeks for baby bonding. And then while employees are eligible for 17 1/3 weeks of PDL, the employee's healthcare provider determines the actual amount of time the employee is considered to be disabled for pregnancy, childbirth, or related medical conditions. So they may only take 12 weeks or 8 weeks. It would all be determined by the medical care provider. They don't automatically, they would be entitled to 17 and 1/3 weeks, but may not necessarily need that much time. PDL and CFRA cannot run concurrently, but CFRA interacts with PDL in that once the employee is no longer disabled by pregnancy, they can begin to use the 12 weeks for baby bonding under CFRA. Some employers may not run FMLA and PDL concurrently, and in this case, let's say the employee is still disabled due to pregnancy and has used up all of their PDL, they can then use up to 12 weeks for FMLA leave if eligible for pregnancy-related disability. And then CFRA leave would come after the disability ends and once the child is born.